Nigeria's banking regulator, the Central Bank of Nigeria, has directed banks to request for social media handles of their customers as part of new approaches to Know Your Customers (KYC). The Central Bank of Nigeria announced this decision last week and has said it means to run more thorough checks on customers using the banks. There are millions of private Nigerians and businesses across various social handles, and the Apex Bank believes its new directive will help combat money laundering and terrorism financing, while it also aligns with international best practices. Many Nigerians have objected to the new move, citing a potential breach of their privacy. I have with me tonight on Politics HQ, the Deputy Director of the Social Economic Rights and Accountability Project, Oluwadare Kolawole. A warm welcome to you, Kolawole. Thanks for joining us in Politics HQ.
Yeah, good evening. Thank you. I'm happy to be here.
Now, Kola, can you elaborate on the specific provisions within the Central Bank of Nigeria's regulations that compels banks to obtain customers' social media handles for identification purposes? What's the rationale behind this requirement?
Thank you very much. And I think the CBN will be in the best position to discharge what is seen as a statutory obligation to convince Nigerians why this regulation is important. And it's very important to also state that SERAP's position on this new regulation of the CBN is not to challenge the powers of the CBN to regulate banking, as of course the established by the CBN Act and other laws. It is the nature and the use of those powers. And in a case in point, in this instance, the directive for the banks to obtain social media handles of their customers as part of Know Your Customer requirements. We believe this is not lawful, given the provisions of the Constitution that grant various rights to Nigerians, particularly the right to privacy and the right to freedom of expression. And the fear is palpable. And really, to speak directly to what you've asked, Gbenga, there are various requirements that the CBN has mandated the banks should do as part of its efforts to combat what is called the threat of money laundering and terrorism financing and all economic crimes. These are issues that we have various provisions that can combat this already. We have the NIN, we have the PVN, and these two measures in itself contains enough data on the average Nigerian for the bank and the CBN and even law enforcement agencies to do their job. And so there is really no necessity. And the CBN is yet to do that, by the way. Now they hold that obligation in using its powers to convince Nigerians why this is necessary and why this must be done, which is why we have the view that this directive of the CBN fails the three-part test, which is an international, they mentioned best practice, international practices, which is in international law, a way of looking at the actions of people and government to see whether they fit into human rights mechanisms worldwide. And that is it necessary, is it legal, and it is proportional.
Now, Kola, quite a lot of people will wonder why your organization, SERAP, is opposed to this. I mean, customers have already given a very private information to the bank while registering. So how does my Facebook or Twitter handle, how is it a problem? How does the collection of customers' social handles infringe upon their rights to freedom of expression and privacy?
I think the question should be examined conversely. The question is, what is the nexus between terrorism financing, economic and financial crimes, and my social media handle? And that is the question we need to ask the CBN. But you see, Gbenga, it's very important to understand the context of governance in Nigeria, which is why this is not strange to us as a people, but this is why we must resist kind of actions by advocacy. You have a government that delights in knee-jerk reactions, knee-jerk regulations, policies, and even sometimes legislations that looks harmful on the face of it. But the use of these regulations have always been found to infringe on the right of Nigerians, particularly when you understand that the precedents that we've seen over the years, right from military rule, even to the onset of democracy in 1999, has been that there are few laws that guarantees the civil liberties of Nigerians. And the few laws that we do have are even disobeyed with impunity by those in power. So we strive to make laws that keeps with international best practice as a way of globalization, but we refuse to also have legislations that would balance and protect the citizens in this instance. And that is the cross of this matter. This regulation looks harmless on the face of it, but what is that security? What is that guarantee that this will not be abused by people like previous legislations, like the Cyber Crimes Act, for instance? It looks good on the face of it, and then it looks harmless. But we've seen government use this time and again against citizens and journalists who dare express what is seen as contrary or critical views on social media. So in this instance, the question that the CBN must answer Nigerians, if at all Nigerians will agree to these, is what is the nexus? What is the requirement of having my social media handle linked to my bank account when you have enough information about me already? That is more or less allows you to do your job.
Now, Kola, what steps has your organization, SERAP, taken so far to engage with the CBN and address these concerns? Have there been any discussions or attempt to seek clarification or revision of the regulations? And have you received any response or communication from the Central Bank of Nigeria in your request to withdraw the regulations?
The step we've taken is we've written to the CBN, we've written a letter capturing our views, our points, and a basic request as part of public interest advocacy to the CBN, which is basically to withdraw this particular regulation that requires, and we're not talking about the whole regulation, just that aspect that deals with the provision of social media handles for individuals, organizations, because the regulation also affects organizations, by the way, and that it is unlawful. That we are yet to get a formal response from the CBN in this regard. And I do hope we get a response that would mean that the CBN is listening to public opinion and that we do not have to end up in court to enforce the right of Nigerians again in this instance.
Now, Kola, as a legal practitioner, can you explain the legal basis of specific laws that SERAP believes supports its claims that the CBN regulation is unlawful? How do these regulations contradict or undermine existing legal requirements and standards?
So, Gbenga, so there are provisions of the Constitution that is called fundamental human rights. And in the wisdom of those that drafted the Constitution, they are inserted in Chapter 4. And the fundamental rights are so important that they are placed in the Constitution. And they have also had enough foresight to understand that other laws will be made. Of course, we have hundreds of laws that have been made outside the Constitution. And that is why they've inserted the provision that if any other law is made that conflicts with the provisions of this Constitution, then naturally that other law will be void to the extent that it conflicts with the Constitution. And so in this regard, this CBN directive is not even a law. It is what is called subsidiary legislation. It is policies and regulations, which of course it's fine. But insofar as it conflicts with constitutional provisions, and in this point, the freedom of expression and the right to privacy, it conflicts, it becomes inconsistency to that extent. And you ask me perhaps, how does this conflict with freedom of expression? You should understand that the right to expression that accrues to you as a human being, which is why they are called human rights, also accrues to you in the digital sense, which is why fundamental rights also transcends the space of digital rights, which is why we can have conversations like this across the digital divide and it's still in that carrying out that right, the freedom of expression. So people own social media handles. It's a sort of a pseudo, you can call it a pseudo world, and people choose to be what they are on these platforms. Linking your bank account to this will infringe on the right of those who are perhaps critical of government or who hold critical views and who want to keep their social media anonymous, or perhaps they have two distinct personalities, perhaps. And again, what makes this very important is the likelihood of the use of these regulations to infringe on the right of Nigerians. And again, I go back to the Constitution. The Constitution has foreseen this possibility, which is why it has inserted in Chapter 4 of the same Constitution that if anyone believes, and I'm going to list the three requirements that the Constitution provides clearly, believes that his right has been infringed on, which is the past tense, is being infringed on, which is the present continuous tense, is likely to be infringed on, which is the future tense, he can go to court to enforce and protect his rights. And in this instance, we are saying that this provision in its use is likely to be used to infringe on the right of Nigerians. We have the right to go to court. We have the right to tell CBN to withdraw this particular provision. We do not have to wait until our right is breached. The mere provision of this regulation breaches those rights, and we do not have to wait until this is applied. And again, we live in Nigeria. We have seen these things happen over and over. So there is enough precedent to convince us that this is one of those policies that looks harmless on the face of it. But the use of this kind of policies will definitely be used by law enforcement agencies to crack down on what is seen possibly critical or dissenting views of those who express them on social media. And again, the CBN is yet to prove and establish how the provision of social media handle is going to further the interests of the CBN, either to combat terrorism, terrorist financing, or money laundering, or any kind of financial crime. The CBN is yet to discharge that responsibility.
Now, Kola, a few weeks ago, just recently, Mr. President signed the data protection bill into law. Do you see this latest regulation from the Central Bank of Nigeria violating this law in any way?
Not in its spirit, but possibly in the use and the applications of this and of this regulation. And the Data Protection Act that the president signed is welcome. But again, we need not celebrate too soon. Nigeria has a lot of laws, a lot of which are disregarded with impunity with nothing happening. So while we celebrate achievements of legislation that protects human rights, we also need to look critically at the enforcement and the adherence to these laws, which are very important. So what we've seen is government using these kind of regulations to breach the rights of Nigerians. And when you look at the context of Nigeria, and this is perhaps global, who is the highest controller or custodian of data in Nigeria? Of course, it's government. Look at your NIN, for instance. Look at your BVN. Look at your driver's license, your car registration, your immigration, your passport. These are data in various forms that exist with government. And as government convinced us of the safety, the sanctity of this data, we do not have that. And that is part of what the Data Act that the president signed is supposed to do. But if government has abused laws over time, including the Constitution, what is the guarantee that this law will not be abused? Either convenient sections that protect the rights of people will be conveniently in law, and sections that appear to give government the right to do what they like will be enforced. And that is what we've seen, which is why the advocacy is not only for laws to be enacted and protect our rights, but also for those laws to be applied above board across the divide, which again is a concept of the rule of law. Everybody is equal before the law.
Now, Kola, if the Central Bank of Nigeria does not comply with your organization, SERAP's request within the given time frame, what specific legal actions or strategies does SERAP plan to employ? And can you outline the potential steps that could be taken?
Gbenga, unfortunately, I wish I would be able to tell you that this will not end up as another public interest litigation. But if the CBN does not listen to the voice of reason, and in this instance, the voice of public interest, we may be compelled to end up in court. And again, one might ask, why do we do this so much? Why do we go to court?
Oh, yes, I was going to come to that. Because critics of SERAP say you don't even allow the government to breathe. There's always a threat of litigation at almost every policy decision of government. How do you respond to critics of SERAP?
I would want to believe that it is either that is mischievous or that is based on ignorance, because the laws are very clear. And really, one need not be a lawyer to understand the purport of separation of powers. Section 6 of the Constitution is very clear. It gives the judiciary the power to adjudicate and determine duties, rights, and obligations between citizens and government, and even between arms of government, which is why we've seen the state government go to court against the federal government. That is what preserves the state from anarchy. It means citizens who have grievances against themselves, among themselves, or the government, should go to court. So as a law-abiding citizen, which is those who made up SERAP, that is what we are. Anytime we feel that government is taking an action that infringes on our rights, we go to the judiciary because we believe in the judiciary. We will not take up arms or do anything unlawful as citizens. We will go to court. We are doing it as an exercise of law-abiding citizens, submitting our grievances for the court to be able to determine who is right, who is wrong. And we've had many instances where the court has sided with SERAP, sided with public interest, giving judgment, but this same government refuses to obey such judgment. So really, you cannot blame a citizen like SERAP for going to court to place the issues before the court for the court to determine. Who we should be talking to are those in government who go to court, contest those cases, lose those cases, and refuse to obey those judgments. So, Gbenga, I really do hope that this does not end up in court. But if, of course, the CBN does not listen to reason, of course, we will have to go to court to compel the CBN to do the right thing, as the law has said that they should.
Now, Kola, as we begin to wind down this conversation, are there alternative approaches or measures that SERAP will propose to ensure effective customer due diligence without compromising individuals' right to privacy and freedom of expression? What are some examples of such approaches implemented in other countries?
Gbenga, what we have is just years of bad governance that created institutions that believe that they can't do what they like. And really, the word national security have been thrown around a lot to infringe on the right of Nigerians to abort due process and just do whatever public institutions like. Of course, those public institutions are driven by personalities who believe they have more powers than the Nigerian citizens. Of course, this is not right. This is not the intention of the law. This is not the intention of the law that creates such institutions. This is just another knee-jerk approach to policy making and legislation to do without analyzing and thinking correctly of the impact this will have on citizens. And so we have the BVN, we have the NIN. And I say this, the CBN cannot refute that these two mechanisms, just some of them, adequately protect the state, adequately allows the CBN and banking to go through while preventing financial crimes and economic crimes. CBN has not come out to say that. This is such another knee-jerk reaction. And ultimately, the citizens will bear the brunt of the misuse of these kind of powers.
Now, finally, Kola, before I let you go, considering the broader context of financial regulation and customer protection, how do you balance the need for adequate due diligence measures within the preservation of individual rights? What principles should guide regulatory bodies such as the Central Bank of Nigeria in striking this balance?
Gbenga, this is very good. And I wish that we have advocacy conversations around this kind of issues enough. And that is why SERAP's advocacy in this instance that raised 3 issues, which I think is applicable to all government actions, be it from the judiciary, the executive, or even the legislature, right from the local government to the federal government. It is simple. Necessity, legality, and proportionality. So it means that every action of government must be legal. There must be a legal framework that allows it to do so. It must be necessary. Those actions must show that those steps are necessary to protect public order. And it must be proportional. It means the responses by way of legislation or policy or actions of government must be proportional to the threat or the perceived threat that it is meant to cure. Most times, policies, laws are made as a knee-jerk reaction to satisfy a requirement without putting this into the consideration. What are we seeking to cure? How do we protect Nigerians for the misuse of these laws? Most times this does not happen in the mind of those who make these policies. They just make them, they misuse them, and then Nigerians ultimately will bear the brunt without any kind of recourse to remedies that would cushion the effect of the misuse of this kind of power. So if government thinks of in terms of its action, within the context of the 3-part test, necessity, legality, and proportionality, I believe that governance can really bear the fruit of democracy for Nigerians. But unfortunately, we've not seen that in years.
Thank you very much. Kolawole Oluwadare, Deputy Director, the Socio-Economic and Rights Accountability Project, SERAP. Always a pleasure talking to you, Kolawole. Thanks for your time and insights.
Thank you very much, Gbenga.